Brad Williams, Labor Compliance Group. I don't even know where to start here. In the previous newsletter, we dealt with travel and subsistence. This is another ruling by DIR that is going to leave you just puzzled, because I'm puzzled. In this particular case, we're looking at a similar situation. Let me just preface this with the previous newsletter last month. We had a situation where the contractor was doing a project in Northern California. They were located in Southern California, and their drivers were driving back and forth. And the argument on behalf of DIR was, we're going to fine you a bunch of money because you didn't pay travel time. And the fine was $78,000 or something to that effect. In this particular case, we have a project up by the Eureka area, up north, up by Oregon. And in this case, let me refresh you on the previous decision. The previous decision, we had individuals driving from Southern California to Northern California. And the ending argument was GC never had control of the workers, and subsequently the $78,000 penalty was waived. And I disagree 100%, because the language within DIR states specifically that travel time, workers are entitled to travel time. In next month's newsletter, I'm going to show you where an individual was fined $250,000 for almost the exact same situation as this example and the previous month's example. But here we have this group, Katch Environmental. They are a group. They were cleaning up homeless sites up north. And in short, they were assessed a $14,000 penalty. They also underpaid training fund contributions by $2,700. This is based on Caltrans. They have their own internal compliance division. When there's a complaint, DIR only gets involved after Caltrans has gone through their process. As you can see here, we have a hearing officer, which is Drayton, but then we have Wong as counsel for Caltrans. Then Clatch appeared through their individual. Then Caltrans maintenance contract manager, Figueredo. This guy plays a big role here. And then we have a Caltrans Labor Compliance North Region. Then you have a Caltrans Labor Compliance. If this was Sacramento County, this would say Sacramento County. LA would have their own compliance, but for the most part, most complaints go from the awarding agent directly to DIR. Anyway, long story short, this group was penalized $14,000 for their workers driving from Fresno to Sacramento. And then from there, it's just a moot point. Those are the 2 points of argument. Now, the language here, I'm going to go over to the provisions, the travel and subsistence provisions for labor. This is all about laborers doing cleanup work. So over here, we're going to see this obscure and absolutely asinine. Again, this is DIR lacks common sense, and I'm just tired of the bullshit and their lack of clarity. We have travel and subsistence provisions, craft labor. Okay, here are all the geographic areas under Northern California labor. We have travel and subsistence. Then we have this right here, this parking provision, which is just normal language. Then we have a supplement. We have a supplement number 2. We have a supplement number 6. And then we have, look at this. Look at this crap. Are you serious? Again, the lack of common sense is just mind-boggling. But nonetheless, why the hell would you ever subject to this much bullshit doing public works projects? This lack of clarity in their language. Then we have this other supplement, number 7. I'm going to go through these real quick, because the argument from this Clatch company is, look, we paid our workers the appropriate travel time. And get off our back, DIR. Get off our back, Caltrans. Well, they did and they did not. Because if you read this, the only provision that Clatch was subject to was labor and a possible zone charge. Here, supplement 2, gunite, concrete, panelcrete, and similar type work, including all placing, finishing, and patching. Well, they weren't doing gunite, so supplement 2 is a moot point. If you continue to read this, they're going to say travel in and out of town expenses. Well, it's not applicable. Then you go down to supplement number 6 and says zone pay. Well, zone pay, and this is not related to the concrete deal. Zone pay at $3 per hour will be added to the base hourly wage rate for work performed outside the free zone. Okay, for purpose of calculating overtime, the zone pay hourly rate shall be either 1.5 times the straight hourly rate or double for overtime. That's pretty clear. Then they map out this ridiculous arrangement here, which is just asinine. Then it goes down, and you can, try to figure this out. It's mind-boggling. Then it goes, zone pay and map changes shall apply for. Now, this is from 2006. This particular document here is the latest. I pulled the document from 2020. That's when this argument or this civil wage penalty assessment was reviewed. So I looked at it and the language is exactly the same. And it says all areas other than the free zone shall be subject to zone pay. All right. That's fine. Individual employer shall not be required to pay zone pay to employees employed by an individual employer in a permanent yard or shop or plant and employees employed by individual employer on residential construction projects. Now, here's something here. It says not camp. What does that mean? Again, DIR, in their lack of clarity, uses this language here. It says, Caltrans with respect to work under agreement number, whatever, for encampment sites, waste removal, encampment sites. Now, are camps here the same as camps here? Here's the civil wage penalty assessment. Here is the travel and subsistence language. Now, residential projects, not camps. Now, are camps where workers stay on long-term projects? Thank you, DIR, for the clarity. So you go in here, it says Caltrans advertises project, cleanup of unauthorized campsites along various states. All right, now, campsites, this is the civil wage penalty assessment or the travel and subsistence. Again, shake your head. Then go into zone pay shall not be applicable within the city limits of the following cities or towns. What does that mean? Does that mean if we're driving through Auburn or Coalinga or Crescent City? Or are we doing work? And then if we're not doing work, see Wairika? The project is up in Wairika and in Crescent City. I think it's up that far north, and I don't think it's defined. But nonetheless, you could see, does this mean work around the surrounding area or not? And then zone pay shall be applied to publicly financed camp. What does that mean? Well, you go back up here. Again, this is the travel and subsistence document. And then here we have this campsites. Well, this is being cleaned up and it's financed money. And I don't know. I don't know what the language is. So it's confusing. And I'm not a lawyer. So just keep that in mind. I'm not giving legal advice. I'm just trying to look at it from your perspective when you try to figure this stuff out. So now you go into here and it says, if a road or highway forming part of zone pay shall apply to publicly financed camps, highways, dams, tunnels, power, sewage proposal, heavy engineering projects, together with camps, warehouses, offices, or facilities constructed. So again, my interpretation is a camp is a long-term project. Let's say this is Oroville Dam in 2020-21, where the spillway absolutely dissolved. A huge camp was built in order to rebuild that spillway. Now, is a camp here, right here, the same as a camp here, unauthorized campsites? I do not know. So again, it says there are some free zones, etc., etc. Then it goes into highway work. It says no zone pay shall be paid on job located with right-of-way of road or highway forming part of the boundary. If a road or highway forming part of the boundary of a zone pay area is relocated, such as relocated road or highway upon being officially open, just shrugging my shoulders going, how do you define this? And then again, is this part of the acceptable supplement? Yes, this is part. Then you go down here and it says supplement, number 7, supplement to the master agreement regarding laborers' work for the concrete wing drilling. All right, so this does not apply. You see these rates here? The travel rate per hour based on group 3 laborers rate. Well, now that's even more confusing. But it's not part of the supplement. Based on group 3 laborer rate, you would pay this applicable rate. Okay, that's agreed upon. And the provisions are clear, but we're looking at labor for cleanup. This is not group 3 labor rate. Again, we're working under this guise that supplement 7 states this is for master agreement regarding laborers' work for the concrete wing, drilling, quarrying, and breaking industry. And the travel rates per hour based on group 3 laborers rate. If you're cleaning up campsites, then this wouldn't be applicable. But if we go over to group 3, here's group 3, construction labor, including bridges laborers, general laborers, and cleanup laborers. That would be applicable if you were classified under this particular requirement, but you're not. So here's the travel rate. Well, that's fine. But if you're not under this supplement 7 requirement, then you have to pay this zone rate. Confusing? Yeah. Now let's see if we can put this puzzle together here. Caltrans advertised this project in 2019, consisted of cleanup unauthorized campsites. So we're going to make this assumption that the camps in the travel and subsistence language doesn't apply here. It's in Mendocino del Norte and Humboldt Lake in Trinity counties. The 3 were not mentioned in the pre-zone city area. So that's not applicable. The project looks like, in effect from August 2nd, 2019 to July 31st, 2022. So it was a 1-year cleanup project. The requirements was to collect, remove, transport, and legally dispose of environmentally regulated, biological, and hazardous waste and contaminated debris. In other words, the crap in homeless sites. So the applicable prevailing rate in the 5 counties at the time was $55.64 per hour for straight time, $71.04 per hour for overtime. All right, contractors shall make travel and or subsistence payments to each worker to execute the work. Okay, the travel and subsistence provision did not apply to this type of work for the use of the... It's clearly stated here. The labor public wage determination included a note that included contractors shall make travel and or subsistence payments to each worker to execute the work. That means for this particular craft, you need to pay travel and subsistence. The travel and subsistence provisions for labor included 3 supplements, and I mentioned them, 2, 6, and 7. Supplements 2 and 7 did not apply to the type of work used for this project. Go back up here. Here's supplement 2. Good night. Here's supplement 7. Then the question here, does supplement 6, and I said this is the zone pay, is it applicable or is it not? Let's go back to the civil wage penalty assessment, and it says neither party addressed whether supplement number 6 applied to this project. All right, and that again is mentioned here. November 18th, Caltrans went on and they said, look, you didn't pay your workers' travel time and you need to pony up a bunch of money. Then Caltrans pushed it further in March of 2020, submitted this matter to Labor Standards Enforcement for approval of forfeiture of the unpaid wages. In other words, DIR withheld payment to Katch. On March 18th, Caltrans issued this notice of withholding. All right, this is just the legal stuff. And it's stating the notice relied solely upon the CPR submitted by Clatch, determined travel time showing payment for travel at rates between, okay, they use this $14.90 an hour to $30 an hour. Katch could have just been shooting from the hip here. So let's go back up here into this determination and see what these numbers look like. Here you're going to go down at a minimum, and this is 2020. There's 1991 here. Then if you took double time, okay, they use $14.90. That number is just some crazy old number. I know there's a provision in here that said you're going to pay your workers. Now, this $14.90 and this $30, they go in and they explain it, but here, this $14.90, I pulled up, this is the prevailing wage rate from 2020. These guys could have pulled something back from 2019. If you take group 3 rate, again, this might be a little bit high, and you divide this by 2, that's going to be about $16 an hour. But if they took a 2019 January rate, it could be $29 an hour. I'm guessing that's how Katch came up with this number. And they have a provision here. It says the CPRs did not indicate the purpose of the travel. Nevertheless, the CPRs did explicitly identify pay for travel hours, either for straight time at hourly rates of $14.90 and $20, or overtime at hourly rates of $22.35 and $30. In the fringe benefit, Katch did what any reasonable person would do. They're going to try to read this document. Then they're going to try to piece it together. And the language is impossible. Again, you have to applaud DIR for their arrogance and the lack of common sense. So Katch did everything they could in order to understand this. They even asked DIR directly for clarification on this requirement. And that's later in this civil wage penalty assessment. And they asked DIR, and DIR punts, as they always do, without providing providing a particular answer. In the end, Figueredo, he's the guy for Caltrans, testified that these folks from Catch were showing up in a vehicle. All right, that's fine. Now, Caltrans goes on and says the type of work, what they were doing. They were traveling to and from point A to point B. The labor compliance officer and this Figueredo is a Caltrans divisional guy for operations. He was actually on site. And this labor compliance officer, Puschel, testified some language that, look, these people were entitled to travel time and it should have been zone pay at the prevailing rate. And they compute some time. It's 10 hours both ways, etc., etc. DIR is going to rest their hat on that previous month's language. And that is, who's under control? Well, there's not so much a control issue here. It's the lack of clarity. You just don't know what to do now. Because in the previous newsletter, tried to explain how impossible it is, and it is impossible. Here, DIR saying these people, they're entitled to 3 hours for labor at the hourly rate of $55.64 and 5 hours for overtime because they're traveling from Fresno to Sacramento. And that the difference equated to minus the $20 an hour that they were paying, or $30 an hour, that the 14 grand was underpayment of wages. Now, this other failure to pay traveling fund contributions is really not that important of an issue. Here is the discussion. First and foremost, you have California prevailing wage law says, look, you sign that particular contract on a public works project, you have to pay prevailing rate. That's clear. I've pointed that out time and time again. There's no ambiguity there. That's pretty straightforward. DIR is going to go ahead and they're going to use this Lasardia construction, et cetera, et cetera. You're going to go on and say, did the contractor do everything correctly? Yeah, in terms of the prevailing rates. Now, the question, the big argument here is this compensable travel time. In the previous newsletter, DIR said Marillion versus Royal Packing, and who has control of the work. In the Dream Builder case, we had Southern California to Northern California. The workers were provided pretty much a choice if they wanted to do the project. They were never forced to do the project. The way the company was set up, it was pretty much a voluntary. If you accept this project, then you understand it's going to be a case where you may stay in Sacramento over the weekends. If not, it's up to you. If you want to drive back to Southern California, it's on your dime. I disagree with that 100%. Why? Because the company, Dream Builder, paid for them to drive down. And then Dream Builder said they'd pay for their lodging and they'd pay for the food over the weekends. Sounds like Dream Builder was still in control. But then if the workers drove back to Southern California, Dream Builders would pay for their transportation costs, but not their prevailing wages. It seems like Dream Builders was still in control of the work. So again, I disagree 100% with DIR. In next month's tutorial, you're going to see why. It's shocking. These two provisions, these compensable travel times on Dream Builder and Catch are mind-boggling. They're absolutely mind-boggling because DIR absolutely 100% changed their ruling. Here again, it's who's in control of the worker. Well, DIR doesn't say anything in this particular ruling or decision about who's in control here. It just says Caltrans failed to meet its burden proving with any type of evidence there was an underpayment of work. We have to go back here. This is travel and subsistence. Supplement number 6 is not even brought up in this particular civil wage penalty assessment. Caltrans never brought up zone pay. And if it's not brought up, then DIR literally rests on these non-applicable supplement. From your point of view, what do? I don't have an answer. I really don't. That's why I'm providing this information to you. Here, Caltrans contends that Catch workers were subject to its control because they were observed arriving at the morning safety meeting in Catch vehicles. Without more, Caltrans failed to show that Catch determined when, where, and how its workers had to travel to the project. They're showing up in Catch's vehicles. Well, that's how, when, the morning before they get to this safety meeting, and where? Well, at the safety meeting. It says, unlike Marillion, where the ag workers were required to take the employer's provided transportation, there's no evidence in the record that the workers on the project were required to take certain transportation to a work site. Unbelievable. Unbelievable. The fact that Catch workers traveled in Catch vehicles is not dispositive. Time employees spend traveling on transportation that an employer provides but does not require its employees to use may not be compensable as hours worked. Does that make any sense? Here, there was no evidence that Katch required its workers to drive or ride in the company vehicles. The Supreme Court emphasized in Prevailing that employers do not risk paying employees for their travel time merely by providing them transportation. And that's it. If all other issues are moot, what does that mean? DIR assessed a $183 penalty. $14,000 was waived. I'm absolutely 100% shocked. Here, there's no issue about control. There's no issue about the proper wage rate. When it says in pretty clear language, right here in the travel and subsistence, zone pay at $3 per hour will be added to the base hourly wage rate for work performed outside the free zone described by the following boundaries along township and range lines. Unless, if you were to parse this out, and I'm not going to, that's your responsibility. If by chance this project was map description for area free zone, then maybe there is something that waived this travel subsistence. But again, I don't agree with that. And I'm not saying that the workers are not entitled to travel pay, but I want clarity. I want clarity so I can discuss this intelligently. I can't, because DIR in so many instances continues to do this. Now, wait until next month's newsletter. You're going to be shocked. I mean, it is absolutely mind-boggling at the 180-degree turn on the part of DIR. Confusing, to say the least. Challenging, even more so. I am sympathetic to the individuals that elect to do public works projects in California. The reason being is you're subject to this. Again, the cost. Hire an attorney to figure this out. Is it worthwhile? I don't know. What I'm doing here is I'm trying to find the provision from DIRs. Katch went on and was very, very aggressive in terms of their understanding of the travel time. So by letter dated December 11th, Katch emailed the Office of the Director Research Unit requesting clarification on the travel and subsistence requirements for laborers in Northern California. On January 31st, 2020, Katch provided additional information as requested by the research unit. On March 13th, the research unit discussed the travel and subsistence requirements of the applicable determination for laborers, and then advised, and this is how pathetic, please note that compensable travel time may be required for any employer-mandated travel that occurs after the first location where the employee's presence is required by the employer. If workers are required to show up at the shop or begin work at the shop prior to traveling to a public work site, travel time is compensable at the required prevailing wage rate for the job. That's just standard language. It took them 3 months to come up and just copy-paste what took 30 seconds to read in the normal language within DIR. It's shameful. It really is. But again, you're subject to these provisions, and all I gotta say is good luck trying to decipher this stuff. Hey, in order to support this ongoing endeavor, in other words, in order to provide these informative newsletters, take a look at the various courses I provide. Be sure to check out our Understanding the California DIR Labor Compliance Rules and Regulations. This is a great course. It's 6 hours and it covers everything you need to know in terms of DIR, including this travel stuff. Federal Davis-Bacon FAQ, I like this. It's just short and sweet, to the point. For those of you doing any type of work in the Bay Area, you need to take a look at the San Francisco Local Hire. Navigating DIR websites, this is an absolute must to the compliance rules. You have to do both, really, because here in this labor compliance rules and regulations is the regulatory side. Over here, navigating DIR websites, I take you through this crooked path and lead you to the correct answer. California DIR prevailing wages, this is great for individuals who are well versed in DIR public works compliance issues, but just can't remember all of the issues. So this is a quick go-to. Federal Davis-Bacon Contractor's Guide, if you're doing Davis-Bacon work, we'll take a look here. And then I'm always available for consulting. Feel free to call me with any questions you might have. If you like this particular newsletter, give me a thumbs up, subscribe, and hit that like button. Brad Williams, Labor Compliance Group. Thanks for watching.